everyone, Harry here, and with the redoubtable Adam Klasfeld, who covers the waterfront literally for different courts, was in Boston yesterday and today, as you can see, near the East River waterfront in New York Thurgood Marshall Courthouse. Often, Trump and the administration are looking to scream emergency, have relief granted. But other times they've been sued, and overall, statistics came out today documenting their really woeful record, top to bottom. But anyway, there's a couple cases that they've wanted to actually stop the music, and they have failed there as well. Adam, on the spot for All Rise News, has just come out of one that's happened in New York, where there was a pretty big fight involving the Department of Education and its efforts to suspend hundreds of millions of dollars in grants to different states. Adam, what's the story with the case, and what happened today with Judge Ramos?
Well, this happened just about an hour ago. Breaking ruling, Judge Ramos reiterated that the department must process the education grants that were COVID relief funds appropriated by Congress. Same old story that we've been hearing all along, Harry, where Congress has the power of the purse, not the Trump administration. And they're laboring on that misconception once again. The most interesting thing about the ruling to me was what happened at the end of the hearing. Because as many viewers know, the GOP House slipped into the big, beautiful bill, so-called, a provision that was going to restrain judges' power to enforce their rulings. So the state of New York, one of the states of this 17-member coalition trying to get these grants unfrozen, told the judge about the bill and the potential that his enforcement power would be restrained, and said accurately the bill allowed him to proceed if he posts a security deposit. So he ordered, a security deposit for the plaintiff. So they requested a $1,000 security, which for the state of New York is not a lot of money. And the judge agreed to order that nominal bond, which means that if the Trump administration does not process these payments, in the judge's words, without delay, there's nothing Congress will do, as this bill is currently constituted. If the Senate passes it, the judge still has the power to enforce this ruling through contempt proceedings. So we're seeing the judiciary adapt to this new threat to take the power away from federal judges.
And let's just talk about that a little. It was slipped in as a sort of freestanding sweetheart provision just for Trump. In theory, what the rules provide is you need to, if it's a civil case, provide a bond equal to the amount. So the $1,000, of course, as you say, is the money from on the block you are on for parking meters, just for an hour. For New York, but it's a big provision, and I just want to put a couple bookmarks in. It's possible that it itself, in a reconciliation process, won't be able to pass with just 50 votes. It might require 60 for labyrinthine reasons. And then, second, we already have some courts asserting their power under inherent equitable principles to suspend that provision and not require plaintiffs to do a full-on bond. So we'll see what'll happen if it does pass. But as you say, Ramos seemed very concerned with making sure he got this case and it would go forward, whatever happens with the, as he put it dryly, big, beautiful bill. Tell us a little bit more. COVID, what the hell is going on that the money had not been distributed and the administration is looking to get its hooks on it?
Well, here's a really interesting thing. Judge Ramos did order the Trump administration to unfreeze these funds before on May 6th. And so the Trump attorneys looked at, well, they wouldn't always be called Trump attorneys, but this is now Trump's Department of Justice,
Yeah.
looked at the provisions and came up with a new rationale for withholding the money. They thought that they could say this is now end of pandemic, and meanwhile, the pandemic didn't go anywhere. It's just
Yeah.
receded from our collective minds. Uh, However, these were COVID relief funds, and that was the new justification. So the state of New York went forward and sought emergency relief. They got it today.
Okay.
And so
So do I have this right? He issues an order, give it up. They go back and say, no, 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 we have a new reason not to. And that's because COVID's over. And he said, no, that doesn't fly. I'm telling you again, do it. And what was the adverb? I mean, do it now. How did he put it?
without delay.
Without delay.
He and that was, it came with a little bit of negotiation. We will see the written order that will give some teeth to it.
Yeah.
But it was a sort of dance where the judge really doesn't know how long, especially in the era of purging the federal government under Trump, how long
Yeah.
these payments actually take to process. So he didn't want to put a number on it, however many number of days, but he did want to give some teeth to it that if they were slow walking it, if they were dragging their feet, there would be some recourse.
Yeah, it's a general theme here. The savvy judge doesn't want to get in a position where the administration can disobey and look like it has some reason that, how do you know how long it takes, et cetera, within the bowels of government. Let me ask you this, Adam. In a couple cases around the country, it seems to me that just in the last few days, the Department of Justice attorneys who before were totally hapless and given nothing to say, actually have been responsive. So today, in an important Alien Enemies Act case, as you probably saw, they proffered a statement that here is what Marco Rubio is going to do. In other words, somebody within the department somewhere seems to have gotten more sensitive to the impossible position that DOJ attorneys were being put in. Uh, did you see that here in the Southern District of New York? Did they actually have positions from their clients and authorized arguments to make rather than just standing up and sort of being flummoxed?
Well, that I did see that happening today. I'll give you an example. They were trying to justify a new argument to deprive the court of jurisdiction under the Tucker Act. Now, it was a new
Right.
argument that they hadn't made before in this litigation, but they came equipped with certain arguments, not arguments that won the day, not arguments that persuaded the judge, but it wasn't the sort of ad hoc thing where we're seeing Emil Bovee come up from
Yeah.
Washington,
Right.
D.C.
Right.
because no one wants to take the table with him. This was something where it resembled normal arguments. But I'll tell you a case that's happening in this very courthouse that has the kind of opposite of that. There's a case of Yunseo Chung,
Mhm.
one of the ones with the crackdown on student protesters. And this one stands apart from some of the cases your viewers might know about Mahmoud Khalil, Rumeysa Ozturk, because unlike these people, Yunseo Chung is not in custody. And so here's a example to your question, Harry, about the government not knowing what its client is up to. Because in Seo Chung's case, she's not in custody because DHS hasn't been able to find her. They haven't been
Right.
able to arrest her. And so the judge tried to break the impasse by saying, her attorneys are sitting at that table. Serve them with a notice to appear, and then she's in custody. You can begin formal deportation proceedings. And the government resisted the solution because they said, I need to consult with my client, ICE, to see whether ICE wants to hold out to see if they can hunt her down and arrest her. The judge, Judge Naomi Rice Buchwald, was taken aback by that proposition and said, if your clients don't want to go with this solution that speaks to their motivation. And
Yeah,
I will take that.
exactly. See, by the way, we have statements like that more and more from federal judges who just wouldn't make them in the past, really second guessing the bona fides and the subjective intent of the administration. But what she was saying here, take the win, United States. I'm letting it happen. And what's on the other side? They obviously want, and the attorney knew it right away because it was sort of frozen and it said, I better check with my superiors. They want the photo op of the ICE guys in mass and ramming down the door. They want that sort of interim effect to immigrants and probably citizens around the country so that, that they wouldn't take. There's been so many cases. We had this, most recently in the cases in New York Newark involved. We talked about them involving Baraka, where they want to make a sort of public spectacle. And here as well, that's part of the concerted strategy. And the judge, was onto it and didn't like it very much at all. So we'll see what happens. But it does, as she said, speak volumes. Adam, as long as I have you and as long as you're covering the whole Eastern Seaboard, I did want to ask you about another case from yesterday in which, again, the Trump administration was sort of trying to stop the music. This was in Boston. And the judge says, no, we are going forward. We're going to have trial and potentially there's going to be liability for the United States. Can you tell us about that one?
Absolutely. Well, this is a case that goes to the bigger picture. I talked about Yoon Seo Chung. I talked about Mahmoud Khalil. This is a case that goes to the policy level. And the plaintiffs here, who are academic freedom institutions, sued the Trump administration and Marco Rubio over the policy of targeting student protesters for speech. And they seek a ruling blocking this policy. Yesterday, the Trump administration went to court trying to deprive the court of the ability to hold this bench trial that is scheduled for next month. And the judge ruled against the Trump administration. The trial is on pace. I'll be covering it in July. That this is a case that goes to the heart of that policy. And he ordered the Trump administration to provide discovery, said that there will certainly be privileged information, but is there some sort of manual, he asked, that justified sending numerous immigration officers to Ramesa Ozturk masked, not identifying themselves, not having a warrant? That is discoverable, he said, if there is such a manual. He said that he is not accustomed to seeing the sort of viral videos that we've seen of these arrests of student protesters, which goes to the spectacle you were talking about a little bit earlier, Harry, that the spectacle of these videos and why the government won't settle for their ostensible goal of deporting Yoon Seo Chung, who would have all of her defenses available if she were in custody. No, they might want to effectuate an arrest. That's going to happen again in this courthouse in a couple of days. We'll find out whether ICE will be a little bit more reasonable or if they're sticking out for that viral video moment, as it were.
Yeah, if the judge will say, I want to see a nice person. Why is this a problem? And she's going to, really nail them to the wall to make them say, because we want to show what big badasses we are. Okay, but back to Boston and this bench trial, the trial, in other words, that the judge will make the decisions. I think it's maybe July 2nd. But what did the Trump administration proffer to try to get the judge to close up shop here?
So they said this is an Administrative Procedure Act case. And under the Administrative Procedure Act, you go over...
Talking Feds listeners know what that is now. All right, go ahead.
Well, so the government said that because it's an APA case, they don't need to move beyond the administrative record, which is already before the judge. The judge said, no, it is also a First Amendment case. And so that's what brought this forward. And that's why, after issuing this ruling, the judge went over his reactions, really seeming taken aback by what he's seeing of these arrests and how unusual to him. And a word on this judge. This is Judge William Young. He's in his 80s. He's been on the bench, appointed by Ronald
Reagan, right?
Reagan.
Yeah.
Yes, absolutely. So when he says he's not accustomed to seeing this, this isn't a rookie judge who hasn't
Right.
been around the block at all. This is a judge who has been appointed by Reagan, seen a lot of cases, and is looking at these arrests, these immigration arrests, and saying this is unusual. And this could speak to a policy that, if I find violates the First Amendment, I could block.
Yeah.
So
And a couple points. So the APA, this has come up in other areas, like with the law firms. Yes, arbitrary and capricious, that violates it, but it also violates it. You just violate the Constitution. So it does encompass. But second, we had today, I don't know if you saw, as you're busy covering the waterfront in different courts, but a whole sheaf of analysis from a Stanford professor who's shown the real escalation in May. The Trump administration lost 26 out of 27 cases. And I think part of it is their legal claims are crappy, but part of it is also that judges more and more, as just happened with this Reagan appointee, getting emboldened to where in the past you're very polite and you tiptoe and you don't question the administration. They've been presented so flagrantly with indications of bad faith and squirreliness that more and more judges, even as this is the guy in Baltimore, the guy in Boston, have come out and basically said, you guys are just not being candid with the court, something you don't want the court to hear. All right, Adam Klasfeld, what's on your plate for next week? Do you know?
Well, I'm constantly monitoring the Trump docket. I'm going to see what's happening with the DDD case. That's the case. Folks may be aware, the case involving the men who were sent on a plane bound for South Sudan. Now that didn't. They did not ultimately get there because they are now in Djibouti, and
They're still on this plane in East Africa, correct?
Right. And
And they're supposed to get hearings and stuff and interpreters, right?
Absolutely.
The judge stopped the music just in time, in contrast, say, to March 15th in El Salvador, right?
Absolutely. And what the latest update from the government was, now the judge's order was they needed to be connected to lawyers for what is known as a reasonable fear hearing, meaning do they have a reasonable fear that if they're sent to a human rights abusing war zone, they could come to harm, especially in a country that most of them are not from. So those proceedings are
It's South
underway.
Sudan, the youngest country in the world, and basically, maybe it's a country Tuesday and not really Wednesday. It's complete bedlam, and so many migrants who were going to Europe through South Sudan had their, it's just a complete crazy. It's it's the low tech torture chamber, if you will, whereas El Salvador is the high tech. All right. Well,
Absolutely.
lucky for whenever we can, we get Adam live, and when we can't, everyone, you can go to All Rise. What's the exact allriseWhat.com? No, All Rise.
Allrisenews.com. Thank you so much, Harry.
Allrisenews.com, where he when he does these things, including ones that are not quite as breaking as some of these we like to talk to him about. You'll find them and sort of everything from the last week, etc. So it's a really good place to follow the breaking news. Not quite as good as having you live at the Thurgood Marshall Courthouse, Adam, but pretty good all the same. Thanks as always for being with us.
Thank you for having me.
Bye-bye.
Always a pleasure. Bye-bye.